In common law systems that rely on testimony by witnesses, a leading question or suggestive interrogation is a question that suggests the particular answer or contains the information the examiner is looking to have confirmed. Their use is restricted in eliciting testimony in court, to reduce the ability of the examiner to direct or influence the evidence presented. Depending on the circumstances, leading questions can be objectionable or proper. For example, this question is leading: were you at KC's bar on the night of July 15? It suggests what location the witness visited on the night in question. The same question in a non-leading form would be, where were you on the night of July 15? This form of question does not suggest to the witness the answer the examiner hopes to elicit. Leading questions might instead name a particular person rather than asking, who? Indicate a specific time rather than asking, when? And so on. Leading questions may often be answerable with a yes or no. The propriety of leading questions generally depends on the relationship of the witness to the party conducting the examination. An examiner may generally ask leading questions of a hostile witness or on cross-examination, but not on direct examination. Leading questions are distinct from loaded questions, which are objectionable because they contain implicit assumptions. Propriety United States equals, while each state has its own rules of evidence, many states model their rules on the federal rules of evidence, which themselves relate closely to the common law mode of examination. Rule 611(c) of the Federal Rules of Evidence provides that, leading questions should not be used on the direct examination of a witness except as may be necessary to develop the witness testimony. Ordinarily, leading questions should be permitted on cross-examination. When a party calls a hostile witness, an adverse party, or a witness identified with an adverse party, interrogation may be by leading questions. Leading questions are the primary mode of examination of witnesses who are hostile to the examining party, and are not objectionable in that context. Examination of hostile witnesses usually takes place on cross-examination. As the rule recognizes, the examination of a hostile witness, an adverse party, or a witness identified with an adverse party will sometimes take place on direct examination, and leading questions are permitted. In practice, judges will sometimes permit leading questions on direct examination of friendly witnesses with respect to preliminary matters that are necessary to provide background or context, and which are not in dispute. For example, a witness's employment or education. Leading questions may also be permitted on direct examination when a witness requires special handling, for example a child. However, the court must take care to be sure that the examining attorney is not coaching the witness through leading questions. Although Rule 611(c) of the Federal Rules of Evidence do not prohibit leading questions on redirect, some states have expressly limited the use of leading questions on redirect. As a practical matter, it rests within the trial court's discretion as to what leading questions may be asked on redirect. Generally speaking, leading questions will be more liberally permitted on redirect in order to establish a foundation and call the attention of the witness to specific testimony elicited on cross-examination. Additionally, on redirect, an interrogator will often ask questions which specifically seek to elicit whether an inference resulting from questioning on cross-examinations is accurate. Although these type of questions will likely result in a yes or no response, they are properly understood to be direct questions, not leading questions, and are permissible. Exceptions to the no leading questions rule, where the witness is hostile to the examiner, or reluctant or unwilling to testify, in which situation the witness is unlikely to accept being coached by the questioner. To bring out preliminary matters, where the memory of the witness has been exhausted and there is still information to be elicited. To help the witness avoid answering on a subject that is prejudicial or improper. See also, suggestive question, similar to leading question but manipulates the respondent to answer in a specific way. Fallacy of many questions, loaded question, push-pull, push-polling. References. External links, Federal Rules of Evidence, Rule 611(c), The Straight Dope Mailbag, What is a Hostile Witness?